Hello, I'm David Roger, General Counsel for the Las Vegas Police Protective Association. I want to talk to you about impounding firearms for safekeeping. And so here is the scenario. You get a call that a person is suicidal, you show up, you're able to legal 2000 the individual, you are lawfully in the residence, the gun is laying on the nightstand and in plain view, and it's loaded. So what do? The department for years, I am told, has instructed officers to impound the firearm for safekeeping. The difficulty with that is that there is no legal authority to impound a firearm for safekeeping. And so here is kind of the thought process that you should go through. Number one, is the item in plain view and you're not conducting a search to find the firearm. The firearm is in plain view. The question is it evidence of a crime? Because obviously if it's evidence of a crime, the Fourth Amendment allows you to seize the firearm or the evidence. Well, committing suicide is not a crime, and so you have to ask yourself, did this person threaten others? And so is there a threat to life that is in play? If the person has merely threatened to kill him or herself, then there is no crime, and it would be a violation of the Fourth Amendment to seize the firearm. And so the question is, what do? The case law is very clear, and so for a 1983 action, in order to sue you civilly in federal court, there has to be a clearly established law. And the Fourth Amendment is very clear. Unless it is evidence of a crime, you can't seize it. In 2019, however, throughout the United States, legislators enacted what we refer to as red flag laws. And it was a highly controversial time, highly controversial piece of legislation because some people believe that it violates the Second Amendment. But nevertheless, the Nevada legislature enacted NRS 33.560. And that is Nevada's red flag law. And it says that if a police officer has probable cause to believe that a person is an imminent threat risk to him or herself, or an imminent threat to another individual, the officer may file an application with the court. This is not a search warrant. It's not an expedited process. You file a petition in court to get a court order to allow you to seize the firearm. And obviously, this is a kind of an onerous task because you have to leave the firearm there. You have to go to court, file the petition, and lay out your probable cause, and then the court has to hold a hearing. So obviously, that's just not a workable law for all of you because you have things to do. And so the question is, what do you do with the firearm? There are some people who say, well, geez, we have to protect this individual from him or herself. And so we have to seize the firearm for safekeeping. Well, think of it this way. First of all, you can't legally. You will also be setting yourself up for a potential civil rights violation case. But think of it this way. When you do a legal 2000, you are telling the doctors and potentially a court that the person is a threat to him or herself. Before the individual can be released, a doctor has to certify that the person is no longer a threat to him or herself. And so when the person gets back home, there has been a doctor, a psychologist, psychiatrist who has concluded that the person's not a threat to him or herself. And so, the idea that we have to protect people from themselves, there is a process in place when you do a legal 2000 to protect them. And then secondly, what is the downside? The downside is that if you seize that firearm and the person goes home and someone breaks into their house in the middle of the night and the person reaches for his or her firearm to protect themselves and it's not there because you took it illegally, you're talking about a huge, huge lawsuit. So I know that it is contrary to what you might consider common sense. Sometimes laws are that way, but you do not have legal authority to seize a firearm for safekeeping just because the person has threatened him or herself. I know that this is going to be difficult to kind of wrap your mind around, but remember, it's my obligation to protect you, your rights, and your family's livelihood, your job, and your finances. And in my opinion, you don't have qualified immunity for seizing someone's firearm when there is no crime and you haven't gone through the statutory scheme that allows you to petition a court to seize someone's firearm. So, I hope that makes sense to you. If you have any questions, please contact me at droger@lvppa.com. And as always, please stay safe.
111, 110.